My name is Anya Neistat. I'm the president of InterJust. InterJust is an international organization that focuses on investigations and prosecutions of atrocity crimes, core international crimes. I have been doing this work for many years, over 2 decades by now, and I do think that I would lie if I said that, like many others, I'm not getting slightly desperate, given where this field is going over the years. I do work as a lawyer, as an investigator, so I often carry out field investigations myself, but also it is part of my role to supervise how we build cases and how we try to bring justice to survivors. And I do think we are, in some ways, in a place now where there is not a lot of hope because of how the world has changed, because of how impervious governments have become. So this whole approach of naming and shaming that we were so comfortable with 10, 15 years ago simply doesn't work anymore. So for me, the main evolution has really been from kind of more traditional human rights documentation and advocacy to what we do now, which is really documentation for the purposes of prosecution. We do not just document to tell the world how bad things are, because we know that in most cases these days, people do know. We do less traditional advocacy because we feel that those we advocate to simply do not listen. So we really switch to very practical approach, I would say, where we are trying to collect evidence that can be used in criminal trials against the perpetrators, where we collect evidence that can bring real, tangible justice to survivors. I think when we're talking about documentation, it's very important to remember that documentation can be done for very different purposes. And each of these purposes has its place. There is journalistic documentation, for example, and now there is more and more what we call investigative journalism, journalism that really goes into issues that were the domain of human rights researchers before. And it's very important, exposure is still important. There is also documentation for advocacy purposes, so more traditional, I would say, methods. And it's just important to understand that this is one approach. And a very different approach, the one that we use in our work and that some of the other partners with whom we work now increasingly use, is documentation for the purposes of criminal investigations, for criminal prosecution. And the difference is quite significant. And I think in this case, if you get it wrong, you can get it very, very wrong. It's not cost-free. It's not like, oh, we collect as much as we can and then we see what we do with that. This approach is very different, and I think that's where we try to improve our work, and we would like our partners to do the same in terms of understanding the ultimate goal from the very beginning, understanding the parameters of the case, of the crime that you are looking at, understanding the elements that you're trying to prove. So thinking as a lawyer first and then as an investigator, because that will really sharpen your approach, that will save time, that will reduce traumatization, not completely eliminated, it's not possible, but the number of people and the kind of questions that you're asking would be very different. And also there would be a significant emphasis on what we call linkage evidence, right? Where we're not only looking into what happened, no matter how horrendous the crimes are, but we're really focused on who did it. And again, that's a very different approach to how we question witnesses, to what kind of additional evidence we collect, to how we even split our time between field investigations and increasingly online investigations, for example. And another aspect which I think is definitely improving, in my opinion, is coordination and cooperation. And in some ways, that's exactly what we have been doing here over the last week, where it's not like it used to be when there is one enormous organization that has everything sort of in-house, but as a result, it goes broad and not deep. Now, at least the way we work is we really partner with specialists, with experts, with organizations, each of which can deliver their own expertise to the case. And the trick is to combine it in a way that is coherent, that is respectful to everybody involved. But ultimately, the results are always better when you combine specialized expertise rather than trying to do everything yourself. I think the biggest problem is not so much the gap between documentation and case building. Of course, documentation for the purposes of criminal prosecution is very different than traditional human rights documentation. And it does create completely different requirements for documenters at every part of the process. Collecting evidence, preserving evidence, analyzing evidence, presenting evidence, and so on. But I think the bigger problem, to be honest, is, if you like, on the receiving end. I think the biggest gap is both the capacity and the will of bodies, law enforcement bodies, investigators, prosecutors in national jurisdictions, if we're talking about universal jurisdiction, to actually take these cases forward. And I think it's improving, and if there is hope for me, it definitely is with these national processes and national promise of international justice. I think there is definitely an improved coordination between civil society organizations and law enforcement agencies, but there is still a lot of work to be done. On both sides, I wouldn't want to put it exclusively on prosecutors and judges who are and investigators who are too slow and too unfamiliar with this work. It is partially on us. As long as we know how to work with them, as long as the information that we present is usable, they will be increasingly open to taking it and turning it into actual prosecutions. But on them as well, I think there is a process of recognizing that their capacity is limited, and that, frankly, without civil society organizations, most of these cases would never go ahead because of access, because of connectivity to the community, to the affected communities, to victims, survivors, witnesses. So there is a lot that we can contribute to the process. And as long as we contribute it professionally, I think ultimately there will be this recognition and, frankly, practical use. As we're listening to documenters, as we're looking at the material that they have already collected, I'm already writing a case in my head. And of course, eventually it will be adjusted to a particular jurisdiction. But frankly, the definitions of the core international crimes are relatively similar across jurisdictions. Yes, it will be adjusted, and that's when we will work with national lawyers in the country where we're going to file, where we will start conversations with prosecutors, investigators about what would be most useful. But the core, the bones of the case are writing in my head as I'm listening to what documenters present. And then, of course, once it's there, and I think it's very important to start literally putting it on paper early on, not waiting for documentation to go endlessly, we would immediately start seeing where the gaps are. And that would allow us to go back to people on the ground who do documentation, in this case, to fill these gaps. We will come back with very specific questions. They could be questions for specific witnesses. They can be questions that relate more to the context, which is very important, because the investigators in Germany or in Uganda or in Kenya, they would not necessarily have the full picture. And as much as we would want them to focus on specific incidents, they do need to understand the context in which it's happening. And that's important to definitions of crimes as well. So, and then, other gaps or other pieces of information that we would need to fill, of course, would be everything that relates to perpetrators. Because very often we start with what happened, and that's normal and natural. But then once we have a clear picture of that, we do need to move to the next step of any information that witnesses might have about the perpetrators from the ground. And that's also in parallel where we start a lot of OSINT, online investigative work, where we would look at all kinds of remote sensing. It can be analysis of satellite imagery in cases where it's relevant. It can be looking through social media accounts of the perpetrators. It can be looking at everything that has been generally published online. In this case, it's a lot. And that is a long, tedious process, unfortunately, but frankly, the process without which modern investigations just do not happen. In some ways, the perpetrators in this case make our life easier by publishing a lot about their own crimes online, but it's kind of funny how people think that it's sufficient. It's by any means not, right? Even if they're confessing to their crimes on a Facebook video for a criminal case, that would not be enough. So that would be the process. And then once it's there, I think, as I said, it will always be this back and forth between what we need from the legal perspective and how close we can get to that standard of proof with what we find on the ground or online. And of course, it is very important in this process to identify the moment where we actually start talking to survivors, not only as witnesses, but as people on whose behalf these cases will be filed, right? Because they're not filed as general submission of information. They're filed on behalf of survivors or families of victims. And there definitely comes a moment where we need to have these conversations. And these conversations might be easy in certain contexts, and in others, they're absolutely not. Because what people are committing to is not only sharing information with the journalists, with human rights organizations, anonymously, they're committing to being in this process potentially for years to come, and to one day stand in court and testify against people who committed the most horrendous things to them and to their families. And this is where we come in more as their lawyers, as their representatives, and people who will accompany them together, usually with national lawyers, all the way. This is where we also start thinking through everything else beyond legal representation that they would need. Very often it's psychological support, accompaniment in much more holistic way than just explaining to them the peculiarities of a legal process. Given that we work usually in contexts where the scale of atrocities is enormous, these cases are usually complex. They involve multiple incidents, they involve multiple perpetrators, figuring out the relationships between perpetrators, the chain of command, all of that it takes time. Again, depending on the context, it may be very difficult to find certain pieces of information or critical pieces of information, or it may be relatively easy. So I wouldn't say that these cases are simple, but I can absolutely say that they do not need to take 20 years. I think that was more kind of an inertia of the system, especially if we're talking about large international tribunals with millions of dollars spent on this process. And one of the reasons we're focusing more on national jurisdictions is because we do think that even if we take slightly smaller cases, we still can link them to the same key perpetrators. So it is a different approach, and it can be done much faster and simpler. We still need to make sure that the process is fair, that the representation is there, that all pieces of evidence are there. And we do have such examples in some of our work where we are talking a few years and not a few decades. And I think, of course, it's not just because we want to be quick or we want to take a new case tomorrow and leave the other one behind, but it's because, as they say, justice delayed, justice denied. And yes, we know that even 20 years down the line, it will be absolutely critical for survivors to see justice done. But it is actually very harmful to justice to be so prolonged and delayed. Memories fade, people lose hope that something will come out of this, perpetrators change locations or die, and it's really, really difficult to build a case or to try a case, to bring it to trial 20 years, even more sometimes, from when the violations happen. So I do think there is a very reasonable compromise there of doing it thoroughly and with survivors' interests in mind at the first place, but delivering this justice at a reasonable amount of time. I think this question about the current state of international criminal justice is always a tricky one. Because on one hand, you look what's happening with the International Criminal Court, all the hopes that were put into it, all the efforts that were put into it, and quite frankly, modest delivery. It's still there and we absolutely need it, but given how much political constraints and time constraints and everything else it faces, I think that makes people think that the project is failing. But that's exactly where people, I think, are forgetting that this is only one mechanism amongst many. And that's, I think, the premise on which InterJust was built, that there are many other options out there. There are many options that are not being used. Our project Meridian is all about showing how and how many national jurisdictions have the ability to prosecute international crimes. And at the same time, how few of them do it now. And I think it's bridging this gap between the number of countries actually involved in this process and those who theoretically can, is really a big part of our mission. But also on very practical, kind of realistic level, it is happening. The number of universal jurisdiction cases is growing exponentially. The level of perpetrators being targeted in these cases is also improving in a sense that we're not going only after small fish. We are trying to target mid to high level perpetrators. The understanding in the community of justice professionals, but also in survivor communities of these processes, of these alternative processes, is definitely improving. And I'm not going to say that, I don't want to paint a rosy picture here that, tomorrow it will all be sorted, but I frankly think the trajectory is right. The trajectory is positive, but this is exactly the moment where we, and we hope many of the partners with whom we work, should put a lot of effort into making it a reality.